Starting from the top, I accidentally stopped this. I had accidentally pushed the button and it made it stop, so I had to start it back. Starting from the top here. This is the prosecutor's opening statements in my case. He said, Fred Batts is also charged in this case. He is a co-defendant. We expect the evidence to be that Fred Batts was right there with the defendant during this thing. We have cut a deal with Fred Batts. He has turned state's evidence. We will call him to the stand, and you will hear he will get a benefit out of doing what he is doing for us. Now what I want to know, does anyone, and that's done all the time too. I am not saying every case, but it's something that happens. We may not want to cut a deal, but we are forced to cut deals. We do want run from it. Does anyone knowing that find that repulsive that we would cut a deal with a guy who was right there when Andre was killed? So you heard the prosecutor say that they cut a deal with Fred Batts in exchange for his testimony. Okay? I'm gonna go to another part of the prosecutor's opening statements, and here's the more testimony. It says, 3 days later, Fred Batts is taken down to the sheriff's department, and he is interviewed about the incident and gives a video statement. It varies from what you will hear today somewhat, and Fred Batts left in that cell alone, and he walked out and was not arrested until 5 months later. What they're not telling y'all is that when they apprehended Fred Batts and took him down to the police station for interrogation, she said he left the cell. It's a question of whether they let him go to wear a mic and try to entrap me, or whether he escaped. They never really clarified that. But anyway, it didn't work because it did not work because they were trying to get Fred Batts to compel me to say some things that were not true. And I'm going to show you that in the transcript where they had to admit to it. During the course of trial, they admitted that they gave him my name and told him to come and try to implicate me in this crime. But what we're talking about today is the deal. It says that Fred Batts will tell you about the events that happened, though, that afternoon on March 20th. And he will also tell you that he has a deal with the state. But members of the jury, that is conditioned on him taking the witness stand, looking at you, and testifying truthfully. So they say he has a deal with the state, and that deal is contingent on him taking the witness stand and testifying truthfully. Now here's page 2.5 in the transcript. It says, now, in addition to Mr. Batts, as Ms. Lunsford told you, there are going to be witnesses like Mr. Batts who will testify. What do I mean when I say like Mr. Batts? Other people who cut deals. Two of them, Gene Walker and a man named Kenneth Friend. Kenneth Moose Friend and Gene Walker. These are probably people. These are people from Huntsville, Alabama. They are notorious informants. Mr. Friend is known as Moose. And as you know, so these are the people they're talking about. So y'all see that these people cut deals with the state in exchange for their testimony. Okay, so Fred Batts is on the stand. He's being cross-examined, and now we're going to ask him about the deal. Here's the deal that Fred Batts had with the state. Right here, State of Alabama versus Fred Batts, case number 001466. Comes now the state of Alabama through his deputy attorney, and this court moves this court in order null processing above cause for the defendant's substantial assistance rendered in the form of testimony against the co-defendant and his future assistance should that be necessary. The state elects not to prosecute. So as y'all can see, they null processed Fred Batts' murder charge in exchange for his testimony against me, and this is the official document on file, signed by Robert Lee Brazard, who is now the district attorney in Madison County, who is now the district attorney. He's no longer the deputy district attorney. He's now the actual district attorney. The first opportunity that we got, the first question to Batts, the lawyer says, now I understand that what you're saying here, I'm saying when they were preparing you for testimony, and cutting the deal with you, did you tell them that Billy Joe had given you information about the murder? I didn't receive a deal. Prosecutor said we would cut a deal. Said we have cut a deal with Fred Bass. Fred Bass on the examination. I did not receive a deal. We have cut a deal with Fred Bass. I didn't receive a deal. Somebody's lying. Alright, that was the first instance. Okay, take you to the next instance. Right here. Let me move these out of the way. Let me move these documents out of the way. Make sure we cover this. Here's the deal right here. They null processed this case. The judge granted that order. Null processed this case. Now he said, now several times you have said, in fact, you said even without me asking you several times, that you didn't have a deal in this case. Is that what you kind of said during your testimony? Yes, sir. Okay. Fred Bass. He done said several times throughout his testimony he doesn't have a deal. Alright. Now, let me see. Okay. They're asking him, now if I pulled out the document they received your case listed as second and really set to go to trial this week, is that correct? Yes. Now you didn't expect the case to be tried once this case is over, do you? I expect to got a court date pending, you know. I hope that he said he hoped that it's not tried and that my lawyer is able to work a plea agreement. But the district attorney has already stated on the record that they've already reached a plea agreement. So we're not sure why he's lying at this point, but we're going to get to that. All right. Do you expect your case to be tried when this case is over? I hope. And what I expect is that my lawyer is able to get with the DA and some type of plea agreement will be worked out. As for now, I had not received any plea. But the key word is that you expect a plea deal. I hope. And you expect it. Well, I hope. So he's saying that he has no expectation of a plea deal, even though we see that the prosecutor has already said we have cut a deal with Fred Bass. The deal has already been cut, but he's lying on the witness stand. All right. Now let's get to the next instance where he lied again. He says, and part of the reason you feel comfortable saying the things you said yesterday and today is because you feel some type of assurance that you didn't have at the time. And that's at the time when he was first apprehended by police and interrogated. Not necessarily. I feel I got a chance to tell the truth about the situation. Well, you had a chance to tell the truth about the situation that day and you didn't do it, did you? No, sir. And what he's saying, that situation where he had opportunity to tell the truth, that is when he said Melvin Ray didn't have anything to do with this crime. Now he's saying that wasn't true, but what he's testifying to in court is true. And the reason you didn't is because you didn't have the promise and the guarantee that you needed. Is that fair to say? I haven't gotten any promise. But remember, we have cut a deal with Fred Bass. Again, Fred Bass will tell you about that afternoon, and he will also tell you that he has a deal with the state. But Fred Bass is continually lying under oath, saying he does not have a deal. And it's clear that he's lying. Everyone in the courtroom, the prosecutors know that he's lying. That wasn't the only time. Let's see what we have here. Okay, he said, let me ask you this. There are several possibilities agreed that you can have. Yes, sir. Your case could be dismissed or null process, to use term. I haven't went over that with anyone. But here's the null process. This is what the state is asking for. Order to null process. The state is asking that his case be null process at this time. And he's saying that I haven't went over that with anyone. But the state is saying repeatedly that that's exactly what they did. That's page 459 and 460. And it's possible that the day you're sentenced, the judge sentence you, that the deal could stand up and tell the judge you corrupt? Is that a possibility? I would hope so. And would you hope so and expect so? I hope so. So, finally, page 160. Is there any possibility that you would be here out of the goodness of your heart because you want to tell the jury what is on your soul without a deal? I haven't got a deal. We have cut a deal with Fred Bass. I haven't got a deal. Page 121 of the transcript. Page 200 of the transcript. Fred Bass will tell you about the events, and he will tell you that he has a deal with the state. I haven't got a deal. Perjury testimony, y'all. Lying under oath to the jury. And I told y'all I was going to show y'all not only how the lies take place in the courtroom, but what happens when we go on appeal and file our appeals against these lies. This is what the court said. The court, going through Fred Bass, let me open it up, show you. This is the Court of Criminal Appeals decision. This is one of their opinions in my case. On the November 21st, 2001, we had raised that issue on appeal about Fred Bass not testifying truthfully under oath about the deal. And this is what the court said. I just showed y'all the trial testimony. This is what the court said. The court said, it is apparent from Bass' testimony that the state had not spoken with him about testifying. And therefore, the state had not discussed with Bass whether he would testify or whether they would cut a deal with him. That's not the one I'm looking for. Okay, this is the one I'm looking for right here. This is what the court said in the second opinion. However, he testified that he was testifying to help himself, that he hoped that he would be able to get a plea agreement, and that the state had not made any promise to him. The appellant did not present any evidence that a specific agreement existed between Bass and the state at the time of trial. Okay, they're saying I don't have any evidence that a specific agreement existed. Here's this specific agreement. March 8th, 2001. No process. I don't know how much more specific I can be, because that's what he testified to. I mean, I don't know how to I don't know what else the court would need. I mean, this is what they said. They said, during cross-examination by Ray's counsel, Bass indicated that he had spoken with the state to explore some resolution in his case only 2 weeks before trial. He never did that. He said, I don't have a deal. Over and over and over. I have not got a deal. I have not went over that with anyone. Are you saying that your lawyer, Mr. Lamley, has not gone over with you the possible consequence of your testimony? No, sir. I mean, I don't know what they were reading from, or if they're reading anything at all, or if they just write something on paper, but it does not jive with what this record shows. And so what I'm saying is, under their laws, these are their laws, and their laws say that if the prosecutor fails to correct knowingly false testimony, fails to provide me with the details of a deal, I'm entitled to a new trial, because my jury has been lied to under oath. They don't know the motivations of the witness. So what did I do? I wrote to my jurors. This is Mr. Peoples. I was a juror in the case of Mr. Melvin Ray. I attended the trial from the very beginning to the end. I heard all the testimony and was aware of any evidence that was presented. At the conclusion of trial, I was selected as the alternate and was dismissed. So of course I did not deliberate. This was unfortunate for Mr. Ray. My opinion at the end of trial was the prosecutor did not prove beyond a reasonable doubt Mr. Ray's guilt. He said, I did not hear one credible witness. Plus, Mr. Ray's defense attorney did not challenge any of the witness or question any evidence. In other words, Mr. Ray did not get anywhere near a fair trial. It was evident that it was a slam dunk for the prosecutor. This is a juror, Mr. Robert Jordan, Tony, Alabama, alternate juror. I've already talked to y'all about the handgun. I asked him a question about I asked him a question about the deal. Okay, it said, did you understand the evidence at trial to be witness Fred Batts did not have any prearrangements made in consideration for his testimony? Yes, because that's what Batts testified to. He said he did not have a deal. Were you ever made aware of the fact that Fred Batts was to have his murder prosecution dismissed in exchange for his testimony? No. This is Mr. Jordan, one of the jurors at the trial. So that's one of the issues. Okay, now this is from the prosecutor right here. He said that trial counsel cannot now be deemed ineffective. The trial court can reflect back to the trial and acknowledge that there was significant discussion in front of the jury regarding the benefit that Mr. Batts would receive in exchange. And this information was part of the case submitted to the jury. Okay, you just heard that. He said that there was significant discussion in front of the jury regarding the benefit that Mr. Batts would receive. But then you look at the court and they say, where did they say it at? Let me see, maybe it's this one. It said the appellant did not present any evidence that a specific agreement existed. This is the court saying that I didn't present no evidence that a specific agreement existed between the state at this time, but you had a prosecutor saying that there was significant discussion in front of the jury regarding the benefit that Mr. Batts will receive. So which one is it? I mean, which one is it? Did the jury know or did they not know? Now I'm going to show y'all something else that transpired in my case to show y'all that this is not a coincidence or isolated circumstance. Okay, y'all remember right here, this is page 205. Now, in addition to Mr. Batts, there are going to be witnesses like Mr. Batts who are testifying. What do I mean when I say witnesses like other people who have cut a deal? Two of them, a man named Gene Walker and a man named Kenneth Freeman. Okay, this is Gene Walker's testimony right here. What is there any specific agreement between me and you? This is the Deputy District Attorney, Madison County's current District Attorney, Robert Lee Bazard. He's talking to Gene Walker. Between me and you, of what you might get out of your testimony? No, sir. Do you expect to get some kind of benefit from your testimony? No, sir. Do you expect to get some kind of benefit? I would hope so. All right. And that comes, you tell the jury, you tell this jury, if you know that comes as far as your sentence. You're talking about the present sentence you're under. Yes, sir. Are you aware that I contacted the federal system informing them that you may be cooperating? Yes, sir. So you know there is a possibility of what is called a downward departure in your sentence? Yes, sir. What did I tell you I expect from you in return for a possible downward departure as far as you know? The truth. Okay. Gene Walker, Fred Batts got his case in all process. Gene Walker got the downward departure. Both of them denying that they had any benefit that they knew of. Is there a specific agreement? No, sir. Okay. Now, let's go to this guy. Kenneth Jermaine Friend. Moose. Okay. Now, go through the little what's your name, whatnot. And so let me ask you this. Do you have some pending charges here in this system, criminal charges? Yes, all right. And did you get to catch up with me having to do with the individual about this case? Okay. If you would, you're here testifying today. You're ready to provide this jury with some information. Yes, sir. Okay. Are you here today because you're a good citizen? Yes, sir. Okay, let me ask you this. Are you also here because you hope to get a benefit from your testimony with any pending charges? No, sir. You're not even looking to get a benefit from me? No, sir. All right. What were the pending charges you had? Possession of cocaine and marijuana. All right. And what happened to those charges? I still got them. Okay. But do you understand that they were null pros? Same thing happened with Fred Batt's case. Null pros. Null pros. Fred Batt's. Null pros. Do you understand they were? Yeah. 2 of my cases were null pros. Who do you think null pros those charges? I don't know. Do you have a guess? The system, I guess. I don't know. Do you think it might have been me? I don't know who done it. What is your understanding about your possibility of having to face those charges? I have to face them. Okay, tell me this. Do you think by coming here and testifying, do you think it might help you in the future in those charges? No, sir. Same stuff Fred Bass saying, right? Sound just like Fred Bass. Okay, let me ask you this. Do you know the fellow seated over there? Okay, this is my lawyer objecting. Your Honor, I asked to approach at this point. All right. Whereupon the discussion was held. This is my lawyer. Mr. Brazard disclosed he had an agreement with this witness in which the charges were null process and consideration for his testimony. In other words, he's lying and he just got caught. And my lawyer just exposed it to the judge that this is another witness, as he said, like Fred Bass. In addition to Fred Bass, there are other witnesses that are going to be testifying, people who have cut deals. And yet the people who my lawyer said would testify to the jury that they have cut deals, other people who have cut deals, 2 of them, Gene Walker and Kenneth Friend, both of them, I don't have a deal. They all lying. Okay, now let's start over. Your Honor, Mr. Brazard correctly and candidly disclosed to me several days ago he had an arrangement with this witness, and the arrangement is that the cocaine possession charge will be null process consideration. That's why Mr. Brazard attempted to get into those things in direct. By denying all of these things Mr. Brazard asked about, I think this witness lied for about the last 5 minutes, and I asked that his testimony be stricken. This is what the district attorney responds. Judge, let me say this. I do not recall telling defense counsel. I do recall telling him I had a null process D charges, but I do not recall saying that was a permanent deal. He's lying. He's full of shit, Robert Lee Brazard. But I agree with defense counsel. Whether this witness is confused or whether he is or whatever it may be, that so far his testimony is not my agreement with him. He don't want to say that his witness is lying. Okay. Now he's getting to it. The court said, let me ask you this. You understand the court asked me about? He told the court he knows no process cases involving your possession of cocaine. Yes, sir. Was there any agreement or any deal you worked out with him in exchange for which you would testify here today? I assume in a true fashion. Mr. Brazard had to answer that for him. Yes, sir. Was there any arrangement or agreement to that effect with Mr. Brazard? Now he playing dumb. What are you saying? All right. You don't have those criminal charges. According to Mr. Brazard, he stated in open court that he null process and dismissed those charges. Is that your understanding? Now he's telling the truth. Yes, sir. Okay. Now, so you see, yet another witness is lying about having a deal with the state. But that's not. I want to point out something else to you all. Let me see. Because you're fixing to see where my lawyer asked that his testimony be stricken. Okay. My lawyer is saying after being led. I contend this testimony is virtually entirely untruthful, and at this point I think the court has the discretion on those grounds that he perjured himself. He is going to testify as supposedly incriminating comments by my statement. If he cannot tell the truth as to something like if the charges were dismissed, and the reading of this transcript will show he gave multiple answers in the last few minutes on that, the minimum, if he is not going to be stricken, I ask that the jury be instructed that what he said earlier is false and misleading testimony. The jury is entitled to know he lied to them for the first 5 minutes, Mr. Brazard. Judge, I will just withdraw this witness, Mr. David, and I ask that the jury be instructed that this witness be withdrawn because he lied, Mr. Brazard. In that case, then, we do not withdraw this witness. That means that he is willing to put on the testimony of witnesses that he know is lying. He know his witnesses are lying, and he still, Judge, in that case, we do not withdraw this witness. So that's how this played out in my trial, where all these witnesses with all these deals lying, one lie after another. But it started with this man, and it never ended. And so what we're saying with regard to Mr. Batts and his testimony is that the prosecutor knew he was lying, allowed him to continue to lie, did not stop his testimony, did not correct his false testimony, even after they admitted that he had a deal. They admitted to it. He lied. The problem is, whereas you saw my attorney object with regard to Mr. Friend, he did not object with regard to Mr. Batts. And so therefore, we never had these facts that he lied put in front of the jury, and that's what we're trying to do now. So those are the facts. That is the case. And we're attempting to establish this perjury, which is clear on the record, and show how wrongful convictions in Alabama occur. And I appreciate y'all's time attending to this episode that concludes the fact that there has been manifest injustice in Alabama, and that this witness repeatedly lied when he said that he did not have a deal in exchange for his testimony. And we clearly have a copy of the deal, and we know he committed perjured testimony, and we're going to make sure those facts are brought out. Free Alabama.